Good afternoon. This is the Business and Labor Committee. We'd like to welcome all of you. Today is Monday, February 12th, 2 days away from Valentine's Day. All of you remember that, and you can thank me for reminding you. I'm Riepe. I'm chairman of the Business and Labor Committee, and I represent District 12, which is a part of the greater Omaha metropolitan area. I will start this morning with, or this afternoon with self-introductions by committee senators. We have two that are still on their way here, I'm sure. But I would like to start with my far right over here, Senator.
Good afternoon, Senator Carol Blood, representing District 3, which is part of Bellevue and Papillion, Nebraska.
Good afternoon, Senator Halloran from Hastings, Nebraska, District 33, which is Adams, Kearney, and Phelps County.
Senator Teresa Iba, I represent District 44.
Which is 8 counties in southwest Nebraska. Thank you.
And to my right is Micah Chafee, who's our research analyst, a law graduate, and from Creighton, for those of you who might be interested. Give him a little plug here, buddy. Logan Walsh is the committee clerk, and our today's sole flyer of our pages is Cameron back here. Cameron's a student at the University of Nebraska. Please silence all phones, beepers, and other distractions from this hearing. And today, before each hearing, all bills to be heard will be posted outside the hearing room and heard in the order that they are posted. On the table near the door, you will find green testifier sheets. If you intend to testify today, please fill one out. Please make it legibly and hand it into the page when you come to testify. This will help us keep an accurate record of the hearing. If you are not testifying at the microphone but want to go on record as having a position on a bill being heard, there are white sign-in sheets at the entrance where you may leave your name and other pertinent information. Also, I would like to note, if you are not testifying but have a position letter to submit, the legislature's policy that all letters and electronic communications that would go into the record must be received by the committee prior to 8 a.m. on the day of the hearing. The senators introducing the proposed legislation, it's their bill, will first present and will be given the time needed. For purposes of the recorded record, we ask each presenter to state one name, to please spell it, and to state who you are representing. And I will likely ask you to do that for each person that comes forward as a reminder. We know there's a great sense of nervousness when you, senators who serve on the committee are encouraged to ask questions for clarification. That said, the presenter and those testifying are not, I repeat, not allowed to ask questions of the senators serving on this committee. Senators may have computers and laptops at their disposal regarding the hearing, so please understand they are paying attention. At times we have found that if there's some compelling piece and it's in the middle of the, or at the conclusion of the presentation, senators might ask you to further comment on that so that we get some clarification, or I might ask you to take a few more minutes just to make sure that we understand what is going on. In the Business and Labor Committee, we will use the light system today to promote maximum engagement for those wishing to express positions as proponents, opponents, and those in the neutral position. Each testifier today will have 5 minutes to testify. When you begin, the light will be green. When the light turns yellow, that means you will have 1 minute remaining. And when the light turns red, please end your testimony. And if you're not aware of that, I may very well ask you to conclude your thoughts and help us move along so that we get anyone and everyone that wants to testify can. The 5 minute rule may change as it has today. Oftentimes we go with a 3 minute light system. As chairman, I will seek to hear citizens who have traveled some distance to each hearing, and we will also acknowledge letters and emails received from all concerned parties at the conclusion of the presentations. We have a strict no-prop policy in this committee. Should you have handouts you wish to share, please share 10 copies or ask our page to make copies. Please be aware that any handouts submitted by testifiers will be included as part of the record as an exhibit. The page will then distribute any and all handouts to committee senators. Following all proponent, opponent, and neutral testimony, the bill presenter is offered the opportunity to close with final remarks. As a committee, we will work diligently to provide a fair and full hearing. We will make every effort to accommodate special needs. Short of an emergency, this committee will not take action on the bill the day of the hearing. At this hearing, we ask you to be respectful of the process and to one another. With that, I would like to turn to the senators for self-introduction. So, Senator McKinney, please.
Good afternoon. My name is Terrell McKinney. I represent District 11, North Omaha.
And I would go to Senator Hunt, would you?
I'm Megan Hunt, and I represent District 8 in the northern part of Midtown Omaha.
Ben Hansen, District 16, which is Washingtonburg, Cumming, and parts of Stanton County.
Okay, so now you know the committee. With that, we will begin today's hearing with LB, it's my bill, 1188. And with that, I will sit out the bill so that I don't try to influence that. And the Vice Chair, Senator Abach, will be chairing that. And the next two hearings, I have 1188 and 1189. So with that, Chairman, you are in charge.
Thank you, Senator. Welcome, Senator Riepe. You're welcome to open on LB 1188.
Chairman, my name is Murphy. It's MERVRIEPE.
Senator, can I interrupt you for just a minute? Can you move the mic down so you're talking into it?
Yes,
Thank you.
thank you.
Go ahead.
Good afternoon, Chairman Ibach. My name is Merv Riepe. It's MERVRIEPE. I am the senator from District 12. I'm here to present LB 1188, which pertains to claims against the state that have undergone approval for payment following review by the State Claims Board. LB 1188 encompasses various types of claims, including tort claims, miscellaneous claims, insurance claims, workers' compensation claims, and agency write-off request. Testifying in support of these claims, we have representatives from the Department of Administrative Services, the Department of Agriculture, the Department of Correctional Services, and other various state agencies, each advocating for their respective write-off request. Present with us today is Mr. Adam Kaufman, General Counsel and Risk Manager for the Department of Administrative Services. Mr. Kaufman will provide insights into the state claims process and address additional inquiries regarding such claims. Thank you, Chairman. I would take questions that I might ask, but there are experts behind me.
Does anyone have any questions for the senator?
Okay,
With that, you will close?
thank you. Yes,
Will
I
you
will.
close?
Thank
Okay,
you.
thank you.
Thank you.
Okay, proponents. You'll state your name for the record.
Vice Chair Ibach and members of the Business and Labor Committee, good afternoon. My name is Adam Kaufman. That's ADAMKAUFFMAN, and I'm the Risk Manager for the state of Nebraska. LB 1188, colloquially referred to as the Claims Bill, provides for the payment of claims against the state of Nebraska. In my testimony, I will briefly provide a summary of the types of claims that can be filed against the state of Nebraska and the statutory process by which those claims are reviewed. The statutory mission of the Department of Administrative Services Risk Management Division is to identify and minimize financial risks to the state of Nebraska. That mission involves managing the preliminary administrative filing of claims against the state, including claims against the State Insurance Fund and the State Workers Compensation Fund. It also involves administering the operations of the State Claims Board. To file a claim against the state of Nebraska, a claimant must file a claim form with DAS Risk Management. The statutory claims filing process allows the state to pay claims for which it likely bears responsibility without engaging in costly litigation. DAS Risk Management's role in that process is largely administrative, and our division relies heavily on agency investigations and the advice of the Nebraska Attorney General's Office. In general, the types of claims available to claimants include tort, miscellaneous, contract, and line of duty claims. With some exceptions, tort claims are, and I quote, any claim against the state of Nebraska for money only on account of damage to or loss of property or on account of personal injury or death acting within the scope of his or her office of employment under circumstances in which the state, if a private person, would be liable to the claimant for that damage, loss, injury, or death. The risk manager preliminarily reviews tort claims based on the agency's recommendations made on behalf of the Nebraska Attorney General's Office. If the risk manager denies a claim based on the agency's assessment of liability, claimants may ask the state claims board to review their claim. Claimants may file suit in the district court for claims that have been denied by the state claims board. Tort claim approvals operate slightly differently. In most cases, the settlement of tort claims with a value of up to $5,000 can be approved directly by the risk manager upon the agency's recommendation. Any settlement of a claim with a value of more than $5,000 but less than $50,000 must be approved by the state claims board. The state claims board must unanimously approve claim settlements with a value of more than $10,000. Any claim with a settlement of a value of more than $25,000 must be approved by the district court for Lancaster County. Claims with a value of more than $50,000 must be approved by the legislature and are thus added to the claims bill. Miscellaneous claims, which are any claims for which the state bears liability but for which there is no specific provision of law, follow a similar process to tort claims. The risk manager may direct payment on miscellaneous claims with a value of less than $5,000 if the director of the agency against which the claim was asserted agrees to liability. The state claims board may direct payment on claims with a value of more than $5,000 but less than $50,000 if the director of the agency against which the claim was asserted agrees to liability and if the agency has sufficient funds to pay the claim. Settlement of miscellaneous claims with a value of more than $50,000 must be reviewed by the legislature. Contract claims are claims against the state involving a dispute regarding a contract between the state of Nebraska or an agency and the claimant other than employment contracts. Line of duty claims are claims filed against the state by the designated beneficiary or heirs at law of a public safety officer who was killed in the line of duty. Line of duty claims must be filed within 1 year of the public safety officer's death. Contract claims and complete line of duty claims must be heard directly by the state claims board. Settlement of contract claims with a value of more than $50,000 and line of duty claims that have been approved by the state claims board must be approved by the legislature. Lastly, litigated claims that the Attorney General's office settles and in an amount greater than $50,000 must be submitted to the legislature for approval before payment can be made to the litigant. These claims could be tort, contract, workers' compensation, or any other kind of claim that was filed against the state. Based on settlements that the Nebraska Attorney General's office believes will be finalized before the close of the legislative session, we do anticipate Amendment AM 2186 to LB 1188. I believe you have a copy of AM 2186 with your materials. Senators, I'm happy to answer any questions related to the statutory claims process that DAS Risk Management follows. But for specific information related to specific claims within LB 1188, I'll have to refer you to those speaking behind me. First off, there's Phoebe Lures from the Nebraska Attorney General's office speaking to the indemnification claim for Richard Hirschenbach, as well as the workers' compensation claims for Landis Johnson and Santino Majut Ekot. Lily Cathay from the Department of Transportation, Ann Kennecke from the Department of Veterans Affairs, Regina Shields from the State Fire Marshal, Michael Greenlee from the Department of Health and Human Services, and Commissioner John Albin from the Department of Labor will testify related to their agency debt write-off claims. Do you have any questions?
Excellent. Thank you for that explanation. Any questions from the committee?
Could you repeat that?
I tried to time it right, so very good.
With that, we'll look forward to testimony. Thank you. Welcome to the Business and Labor Committee.
Good afternoon, Vice Chair Iba, members of the Business and Labor Committee. My name is Phoebe Lurs. That's PHOEBELURZ. I am an Assistant Attorney General in the Civil Litigation Bureau. LB, as Mr. Kaufman mentioned, LB 1188 provides for the payments of claims against the state. I'm here to speak to two claims that are in the bill that you currently have, an indemnification and a workers' compensation claims. These are both settlements that were settled by the Attorney General's office on behalf of the state, its agencies, and its employees. So Section 1 of the bill covers indemnification claims, specifically indemnification claim CI 20-918 is a settlement entered into by our office on behalf of the Nebraska Department of Agriculture in Lancaster County. It was a claim by Mr. Richard Herkenbach. He filed a claim of retaliation against the Department of Ag. The total amount of the settlement was $150,000. $50,000 of that has been previously paid pursuant to statute, and the remaining $100,000 has been placed into this bill for approval and payment. Section 2 refers to workers' compensation claims. The claim in LB 1188 is on behalf of Landis Johnson, who filed a claim or a workers' compensation suit against the state after he sustained an injury while working for the Department of Correctional Services. It was a slip and fall. This claim was resolved for the amount of $325,000. $100,000 of that has been previously paid pursuant to statute. The remaining $225,000 has been placed into this bill for approval and payment. Our office would recommend each of these claims be approved. However, we would also like to advise the committee, as Mr. Kaufman mentioned, that because additional claims are settled after LB 1188 was originally drafted, we anticipate an amendment. This is obviously not uncommon, as many of you know. I can give you a brief summary of those just because some of them are significant in number. For specifically, our office settled a tort claim involving Miles and Christy Margaret's on Friday for the amount of $7.5 million. That was an alleged police pursuit case that, pursuant to statute, if a pursuit occurs, the state of Nebraska is strictly liable for the damages to an innocent third-party bystander. Strict liability means that if a pursuit occurred, the state is responsible regardless of any fault or lack thereof for the party's damages without any sort of cap on the amount of damages that that party can potentially recover. So that amount will need to be approved and appropriated for the full $7.5 million. However, at the time of this accident, the state did have insurance, excess insurance, several layers, so that a portion of that amount will be reimbursed to the state. However, the state is initially responsible for paying the full amount. Of note, I do not believe that we have that type of coverage any longer. So if this type of claim were to happen in the future, the state would be responsible for the full amount of any damages. We also anticipate a workers' compensation claim on behalf of Santino Acott for $450,000. He is an NDCS employee who was injured when he was assaulted while working at the Department of Corrections. $100,000 of that claim has been paid, and $350,000 will need to be approved and appropriated by the legislature. Finally, there's one remaining workers' compensation claim for Christine Schmidt in the amount of $235,000. She is a Nebraska employee who was working at the Department of Veterans Affairs. She sustained an injury to her back while assisting a resident. So that claim still needs to be approved by the Workers' Compensation Court, but we anticipate that it will be approved in time to be added to an amendment. So I would be happy to answer any questions you might have, and following me, I believe our agency representatives to speak to the write-off claims.
Great, thank you very much. Are there questions for? Seeing none, thank you very much. Next proponent or testifier. Welcome.
Thank you. Good afternoon, Vice Chair and members of the Business and Labor Committee. My name is Lily Cather, spelled Lilykathere, and I'm the Chief Financial Officer for the Nebraska Department of Transportation. I'm here today to testify in support of the department's write-off claim as found in LB 1188. The department respectfully requests your approval of the write-off request in LB 1188 totaling $201,107.22. The Nebraska Department of Transportation has the duty and responsibility to protect and maintain the 10,000-mile state highway systems and NDOT's numerous maintenance yards and other facilities across the state. From time to time, that infrastructure gets damaged due to the action of others. Most of the items that make up the write-offs involve motor vehicle crashes that damage highway guardrails, traffic signs, right-of-way fences, or state vehicles. NDOT has a detailed process it follows to estimate the damages and collect the costs to repair, reconstruct, or replace state property damaged by the public. NDOT works hard to attempt to collect every dollar of damage caused to the state property, and efforts include letters from the state property damage coordinator, as well as phone calls and letters from our agency legal division. NDOT's attempts to collect for this damage are sometimes unsuccessful for multiple reasons, including but not limited to the responsibility party cannot be identified or located, the party has no insurance or insufficient insurance limits, the party has insufficient assets to pay off the indebtedness, or sometimes the responsible party is in bankruptcy or deceased with no assets. The items deemed uncollectible have been reviewed and approved for write-off by our legal division, by the traffic engineering division engineer, or by the deputy director of operations, depending on the dollar amount. Accordingly, NDOT believes these amounts are now uncollectible, and NDOT recommends that they be written off as part of LB 1188. Thank you for the opportunity to testify. If the committee has any questions, I'll be happy to answer them at this time.
Thank you very much for your testimony. Are there questions from the committee? Seeing none, thank you very much.
Of course.
Next testifier.
Good afternoon, Vice Chairman Ibach and members of the Business and Labor Committee. My name is Regina Shields, REGINA SHIELDS, and I am the agency legal counsel and legislative liaison for the Nebraska State Fire Marshal Agency. I am here today to testify in favor of LB 1188, specifically claim number 2024-23326, and respectively asked to write off $1,690 of debt that has been deemed uncollectible. This amount comes from the conveyance inspection fees and underground tank registration fees that were unpaid due to a variety of reasons, including bankruptcy, business closures, COVID-related shutdowns, and owner transfers. These fees were all from 2019. The agency's efforts to collect these amounts have included sending multiple letters requesting payments, past due notices, and phone calls. It's been determined that the cost of additional collection efforts would exceed the amount owed, so the agency respectfully requests that these amounts be written off. Thank you for your time, and I'd be happy to answer any questions.
Thank you very much. Other questions? Seeing none, thank you very much.
Thank you.
Next testifier. Thank you. Welcome.
Good afternoon, members of the Business and Labor Committee. My name is Anna Kenneke, ANNAKOENEKE. I'm the Accounting and Finance Manager for the Nebraska Department of Veterans Affairs. I'm here to discuss our agency's write-off requests. These debts are from 3 members who resided in the Eastern Nebraska Veterans Home. One was for a member who only resided at the home for 4 days before voluntarily discharging themselves, and 2 who passed away without any estate from which to pay their member contribution fees that remained due and owing after the members' deaths. Member contribution fees are the costs that the members pay for their care while living in the veterans' homes. Efforts were made to collect these sums, but were unsuccessful. Further efforts would not be fruitful because none of the members have an estate or assets from which to recover the amounts owed. All 3 members lived at the Eastern Nebraska Veterans Home in Bellevue. The total of these 3 outstanding debts is $8,829.58. We respectfully request that the committee advance the portion of this bill, which includes our request to write off these claims as they are uncollectible. This concludes my testimony. I will answer any questions you have.
Thank you very much. Other questions from the committee? Seeing none, thank you very much.
Thank you very much.
Next testifier. Welcome.
Thank you. Good afternoon, members of the Business and Labor Committee. My name is Michael Greenlee, MICHAELGREENLEE, and I'm an attorney with the Department of Health and Human Services. I'm here to testify in support of LB 1188, which will permit the Department of Health and Human Services to write off certain debts owed for fiscal or accounting purposes and to provide additional information. The total debt for which DHHS is requesting write-off authorization is the amount of $1,495,028.34. The requested write-off amount relates to debts owed to DHHS by way of assistance provided through 14 different programs. The debts are due to overpayments made or for services provided for which the department has not been reimbursed. Prior to submittal of these debts for write-off, the agency pursued recovery through one or more of the following efforts: regular billing statements, recoupment, demand letters signed by the program, by one of the agency directors, and or by one of the agency's attorneys, and finally, litigation. Approximately 99.9% of the debt being submitted for write-off is being submitted because the debtor has passed away with no probate being filed, because the debtor has had the debt discharged in bankruptcy, or because the applicable statute of limitations has passed to include money owed from persons who remained on needs-based assistance. The majority of this year's submission, nearly 91%, falls within the third category, debt that is uncollectible as the statute of limitations has passed. Much of that debt is owing from persons who were in needs-based assistance at the time their debt went past the limitations period. Of those accounts, just over 94% involve debts that there has been at least 5 years since the last payment has made, and so statute of limitations has run. The remaining 1/10 of 1% of this year's total write-off requests involved 8 individual accounts of less than $100, averaging approximately $31.09 each, where we have sent billing statements, mailed demand letters, and made telephone calls to no avail. Thank you for the opportunity to be here today. I'm happy to answer any questions you may have.
Thank you very much. Are there questions from the committee? Seeing none, thank you very much. Next testifier. Welcome.
Thank you. Vice Chairman Ibaugh and members of the Business and Labor Committee. For the record, my name is John Albin, JOHN-ALBIN, Commissioner of Labor on behalf of the Nebraska Department of Labor. I'm appearing here today in support of LB 1188. The Nebraska Department of Labor has 2 separate claims for write-offs this year. NDOL is seeking to write off both unemployment insurance benefit and tax debt. As some of you may recall, NDOL first started writing off debt in 2018 and promised to go forward on an annual basis, and we continue to honor that promise. All the unemployment debts proposed for write-off have been the subject of multiple collection efforts. NDOL is seeking to write off debts over 5 years old that have not had a repayment of any kind in the last 3 years, debts that have been written off through bankruptcy, and debts of businesses that have closed. For claim number 2024-23327, the Department of Labor is seeking to write off $931,307.28, which consists of $371,869.46 in unpaid unemployment insurance taxes and payments in lieu of contributions, $11,028 in penalties, and $548,409.82 in accrued interest. Unemployment tax debts accrue interest at 18%. This number consists of 348 separate employer accounts the department has determined uncollectible. As previously stated, all the debts written off are for employers that have gone out of business or had their debt written off in bankruptcy. For claim number 2024-23366, Department of Labor is seeking to write off $1,017,071.36 in unemployment insurance benefit overpayments. This number consists of 1,278 separate overpayments that the department has determined uncollectible. There's no statute of limitations on any of the aforementioned debts, so the Nebraska Department of Labor is seeking to write off this uncollectible debt. NDOL actively pursues delinquent tax payments. When a business fails to pay unemployment taxes, NDOL makes several attempts to collect on the overpayment. NDOL has statutory authority to collect through civil action, set off against state income tax refund, and set off against federal income tax refunds. Further, NDOL may place a state tax lien on the business, and if personal liability is established, we may pursue personal liability of an individual employer, partner, corporate officer, or a member of a limited liability company or limited liability partnership. Put this write-off of $931,307.28 in perspective. In 2022 alone, NDOL collected $87,077,116.43 in UI taxes, of which $10,703,891 was delinquent. NDOL goes through similar lengths to collect unemployment insurance benefit overpayments. Before an unemployment insurance benefit debt is determined uncollectible, the overpayment has gone through several collection efforts. NDOL has statutory authority to collect through civil action, offset against future benefits, set off against any state income tax refund, and set off against federal income tax refunds if the overpayment is due to fraud or misreported earnings. If a claim is filed for benefits since the debt was established, the department has attempted to recoup the overpayment. Some may have had levies placed on their wages. Of the 1,278 overpayments proposed for write-off, collection of all debts has been attempted through the Nebraska Department of Revenue State Income Tax Offset Program, and 305 of the debts were run through the IRS Income Tax Refund Offset Program to attempt collection against federal income tax refunds. NDOL makes every effort to collect all outstanding debts and has litigated collection efforts in both state and federal courts. Put the benefit write-off of $1,017,071.36 in perspective. In 2023, NDOL paid out over $74 million in unemployment insurance benefits. Additionally, NDOL has implemented new processes to further reduce the overall number of overpayments as established. NDOL has partnered with an outside vendor and has increased first payment timeliness from 43% to 90%, while meeting federal quality standards. NDOL has reduced its improper payments from 16% in 2022 to 14% in 2023. This concludes my testimony. I'd be happy to answer any questions you might have.
Very good, thank you. Are there questions from the committee? Seeing none, thank you very much.
Thank you.
Any other testifiers or proponents of LB 1188? Anyone in the opposition? Anyone here in the neutral? Seeing none, thank you. Senator Riepe, would you like to close?
Thank you, Senator or Chairman Ibach. My only closing would be is an expression of my appreciation for everyone that's testified today and for all the hard work I know that has happened to back up all the settlements of these claims and to do justice. So with that, I would like to conclude my comments.
Are there any questions for the senator? Seeing none, thank you very much. That will conclude our hearing on 1188, and we will ask you to hang around for 1189.
Okay.
Thank you. We'll now open our hearing on LB 1189. Senator Riepe, you're welcome to go ahead and open.
Good afternoon, Chair. My name is Merv Riepe, M-E-R-V-R-I-E-P-E, and I am the senator from District 12, which is the Omaha metropolitan area. We will now move to LB 1189, which are denied claims. The purpose of LB 1189 is to introduce claims filed against the state denied by the State Claims Board. At this time, there are no denied claims by the State Claims Board. Therefore, we may close LB 1189.
Very good. Thank you. This is interesting because if we have no claims, we have no testifiers. So
I would assume
that will
that.
close our hearing on 1189. Thank you, unless anybody has questions. Oh, we have to go through it. Sorry. We have to go through proponents and opponents. I'm being prompted. Are there proponents for 1189? Seeing none, are there any opponents for 1189? Seeing none, Senator Riepe, you're welcome to close, or neutral, sorry, are there neutral testifiers? And seeing none, Senator Riepe,
I
you're
have my 30-minute closing already. that I'm-
waiving. Senator Riepe is waiving close, so that will close our hearing on LB 1189. Thank you very much. I'll turn the mic back over to the professional.
Thank you all. With that, we're going to move on to LB 1408, which is Senator Sanders, and it's on human trafficking. So with that, I see her LA here.
She's coming from education.
Okay. Should we play background music until?
Nope. Thank you.
You home? You feel that? Yes. Mr. Fernandez. We'll have to turn the minutes back on. Welcome, Senator Sanders.
They've got machines in here.
We know we've rushed you a bit, but if you feel composed and you're ready to go on 1408, we're eager listeners on the human trafficking.
Out of breath, but I'm good to go. Thank you very much, Mr. Huss, Senator, Chairman, Riepe, members of the Business and Labor Committee. My name is Rita Sanders, RITASANDERS, and I represent District 45, which encompasses much of Bellevue and the Offutt community. LB 1408 requires hotel employees to take mandatory human trafficking awareness training. This training is provided by Attorney General's office at no cost to the recipient. Several key components this training has is the definition of human trafficking and commercial exploitation of children, differences between labor and sex trafficking specific to the hotel sector, guidance on how to identify individuals at risk for trafficking, and guidance on the role of hospitality employees in reporting and responding to this issue. Prior success rate in other states not only shows the importance of this, but also the need. Since the release of human trafficking awareness training in 2020, 1.2 million hotel workers have been trained to identify and recognize the signs of human trafficking. LB 1408 seeks to bring this vital training to Nebraska. We as a community and legislature have the ability and the duty to protect the vulnerable against the crime of human trafficking. Thank you very much, and I'll answer any questions you may have.
Any other questions from the committee? I think the point of clarification, I talked with staff earlier, is that hotels and motels are synonymous here, that the hotel terminology includes motels as well.
Yes. And I think there's someone after me that will report from the Hotel Association.
Okay, very good. Seeing no other questions, thank you very much. Will you be here for closing?
Yes.
Okay. We would like to now go to proponents. If you would be kind enough to state your name, spell it, and then tell us who you represent.
Absolutely. Thank you guys so much for having me. Good afternoon, Chairman, members of the committee. My name is Katie Wright, K-A-T-I-E-W-R-I-G-H-T, and I'm the Senior Director of State and Local Government Affairs at the American Hotel and Lodging Association. AHLA is a singular voice representing nearly 30,000 members, encompassing every segment of the hotel industry, including major chains, independent hotels, management companies, REITs, bed and breakfast, industry partners, and more. AHLA strives to be an indispensable resource, serving, supporting, and advocating on behalf of the American hospitality industry in order to build a vibrant and united hospitality industry that powers America's economy. Let me be clear. There is no room in the hotel industry for human trafficking. AHLA strongly supports the legislation before you today. AHLA and our members have a longstanding commitment to train every employee in our industry on how to identify the signs of human trafficking and the resources to notify law enforcement. We've worked with globally recognized anti-trafficking organizations to develop and deploy effective training. The bill in consideration today is just that, a promise we committed to and our execution on that promise. The hotel industry is leading the private sector response to trafficking. Trafficking networks often rely on legitimate businesses to sustain their illicit and illegal operations, and hoteliers are uniquely positioned to continue leading efforts to identify and disrupt this terrible practice. Every day, hoteliers play an important role in combating trafficking through raising awareness, coordinating with law enforcement, and ongoing workforce training. The fight to end human trafficking has no finish line. Raising awareness and training is an ongoing commitment by our industry and part of the culture we have built. As an association and in conjunction with our foundation, members and partners, we have trained nearly 1.2 million hotel employees to spot the signs of human trafficking. We've worked with partner organizations to develop a virtual training, and as an industry, we're committed to training all of our employees. I speak in support of this bill, and I hope you will support it too. Thank you again for allowing me to be here today, and I'm happy to answer any questions the committee may have.
Thank you very much for being here. The questions from the committee?
Chairman Riepe.
Yes, sir.
Thank you, Chairman Riepe. Just curious, I don't expect you to go through the whole protocol of your training, but what are the first two several steps that are involved with training staff if they recognize someone as potentially human trafficking?
It's to call the Human Trafficking Awareness Hotline and let local law enforcement know.
Thank you.
Are there other questions? Seeing none, thank you very much for being here.
Thank you.
Our next proponent, please. For those of you who maybe you've just joined us, we are now working on a 5-minute clock as opposed to normally we use a 3. So it gives proponents, opponents, and neutral more time to testify. If your name, please, and
Thank you. Yeah, absolutely. Chairman Riepe, members of the Business and Labor Committee. My name is Rich Otto, Richotto, testifying in support of LB 1408 on behalf of the Nebraska Hospitality Association. Thank you to Senator Sanders for introducing this bill. As previously mentioned, 1408 does mandate that each hotel employee take this training within 6 months of employment. So that they can recognize the signs of human trafficking. Our association wants to be part of the solution in this. We also am encouraged by this. The training is provided by the Attorney General's office at no cost. As the previous testifier mentioned, the American Hotel and Lodging Association has worked diligently on this training, so it is turnkey. We have the appropriate items to bring in front of our employees to get them aware of this. One of the other provisions that I personally like is the right to cure, the 90-day, but they do have 90 days to get in accordance if there is something out of step where a few employees maybe haven't done this. The Nebraska Hospitality Association, again, agrees with everything that was in the testimony of Ms. Wright, and with that name, how could she be wrong? We encourage the advancement of LB 1408. Happy to answer any questions.
Other questions from the committee? I have a question. How do you promote compliance?
Well, we see this most likely to be done similar to like the Serve Safe and other things. The Hospitality Association has restaurants that we've had to comply with serving of alcohol, right? We anticipate that that will be done in a similar fashion, working with the Attorney General's office to make sure that our member employees, our member companies are encouraging their employees. There are significant things for the employer if they don't show that all the employees have passed the training within that 6 months. But we want it to be a ongoing conversation with the Attorney General's office, so we're promoting it and making sure that companies are in compliance.
Do you have, under a carrot and stick concept, do you have a stick at the end that if they don't comply?
Well, this is more carrot, I will give you that, but we anticipate that there is a stick. I can look into the details in our conversations with the Attorney General's office to see what that stick approach may have as part of it, but as of today, it's predominantly a carrot.
Okay, so no financial penalty.
Right, I believe there would be tools for the Attorney General's office to move forward with those. I can get the exact fines and penalties potentially that the Attorney General would consider appropriate.
I would assume the Attorney General would also have the bully pulpit to be able to force compliance.
Absolutely.
Or shame people, I suppose, to it. Okay, are there other questions from the committee? Seeing none, thank you very much for being here. Next proponent, please. Are there more in speaking in favor of proponents? Thank you. If you would, please, if you would give us your name, spell it, and then who you represent.
Absolutely. Thank you. Good afternoon, Senator Riepe and members of the Business and Labor Committee. My name is Karen Bowling, and I serve as the Executive Director at Nebraska Family Alliance. We are a nonprofit, faith-based research and education organization, and we represent a diverse network of thousands of individuals, families, and faith leaders. Nebraska Family Alliance is proud to support LB 1408. When we entered from the public policy standpoint about 10 years ago, in dealing with human trafficking and what we could do from a policy standpoint to see this injustice addressed, we began to realize how important the hospitality industry was in exposing this and helping bring resolve. We actually set on the first task force. After accessing a decade worth of statistics, the Polaris Project confirms that 75% of human trafficking survivors reported coming into contact with hotels at some point during their trafficking situation. And I've given you 4 pages of that report. This has led to a series of state laws, including what Nebraska already had, but We are now just also beginning to clarify what that education process will be. Information is power, and it is a vital tool for the trafficked victim who is desperately looking for a way of escape, but also for the hospitality industry to be better informed on how best to recognize the signs of trafficked individuals to provide better outcomes. I've actually sat in the training of the AG's office in two hospitality industries, one in Omaha and one in Lincoln, and it is very, very resourceful. I have changed the names of 3 individuals who Nebraska Family Alliance came close contact with, for obvious reasons. All 3 are Lincoln women. One was a minor, one was in her 20s, and one was 58 years of age, who experienced trafficking right out of the city of Lincoln. Shannon had recently graduated from Southwest High School and was attending Southeast Community College on a full scholarship. Her mother began to see a drastic change in behavior, and she would be gone for 3 or 5 days at a time. Her so-called boyfriend began to traffic her on the I-80 corridor, using hotels across Nebraska and threatening her by telling Shannon that they would kill her mom and her siblings. Debbie was a young adult woman with 3 small children who became a victim of an escort business run by her trafficker. Her most trafficked day was during Husker football Saturdays. Out of fear for the lives of her 3 small children, she became fearful to report what was happening in hotels across Lincoln and surrounding areas. Carla had relapsed into a crack addiction. A man promised her drugs if she provided a sex act. She had escaped her trafficker, but called us because she saw what was taking place in hotels around our state. Fortunately, because of our relationship with the Innocence Lost Project and FBI, we were able to bring law enforcement into the situation. And that hotel, actually, the Attorney General does have the ability to use the hammer when needed. All 3 survivors have found hope and healing, but recognize it took months and one victim 3 years. 80% of commercial sex occurred at a hotel, according to the On-Ramps Intersection and Exit Routes report by Polaris Project. Had an employee of a hotel recognized the signs of trafficking, or a poster had been displayed prominently, their rescue could have happened sooner. And I am so appreciative with the hospitality supporting the importance of not only training of employees, but also posters. So a victim may see a sign that could simply be the result to help her know where she can get assistance, where she or he can get assistance. So I thank Senator Sanders for bringing LB 1408, and I'll answer any questions if you have any.
Further questions from the
Great. Thank you. Thank you.
I have a question, maybe it's a concern. I know on the second page of your report, it said that 4% trafficked by a hotel.
Yes, yes. So when you're asking that question, Senator Riepe, as far as the victim themselves, because oftentimes their property, like their license plate, anything, becomes actually the property of the trafficker. And so that is under duress that their charge card is being used.
Wow, okay. Thank you very much for being here. No further questions. Thank you very much.
Thank you.
We'll move on to proponents. Do we have additional people that want to speak on behalf of LB 1408? Come forward, please. If you're a proponent, you want to speak as an opponent? Neutral. Neutral, okay. Okay, well, we're going to move on to opponents if there are there some who wish to speak against this. you very much. You know the routine name, spell.
Yep, I even have it written out to spell my name, just in case I would forget. That has happened. Good afternoon, Chairman Riepe and members of the Business and Labor Committee. My name is Randy Scott, RANDI-SCOTT, appearing today as a registered lobbyist on behalf of the Nebraska Association of Trial Attorneys, or NATA, in opposition to the immunity from liability provision only on LB 1408. NATA is an organization of attorneys from across Nebraska whose main interest is upholding the right to trial by jury under the 7th Amendment of the United States Constitution and Article 1 of the Nebraska Constitution, and also the open courts provision under Article 1 of the Nebraska Constitution. So as such, we look out for immunities from especially civil liability, as they prevent a jury of peers from deciding a case and instead allow the legislature to preemptively deny access to the courts. So LB 1408 includes an immunity from liability on page 7. For owners, operators, and employees for any acts or omissions related to third-party trafficking at a hotel unless they knowingly assist. We have spoken to Senator Sanders and the American Hotel and Lodging Association about our concerns, and we're hopeful that we can make changes to that section. If we can come to an agreement on language regarding that immunity from liability, our opposition to LB 1408 would fall away. Again, our opposition is strictly to that provision only in the bill and not to any content or to the purpose of the bill. That is all I have for you today, and I will take any questions. Thank you.
Thank you very much. Are there any questions from the committee? Seeing none, thank you very much. Are there other opponents? Those wishing to speak in opposition? Seeing none, is there anyone that wants to speak in a neutral capacity? We have one young man. Welcome. If you would be kind enough to please state your name.
Okay.
And spell it for us, please, for the record,
Yes, sir.
and then who you represent.
Okay. My name's Scott Thomas, SCOTTTHOMAS. I'm the Regional Director for the U.S. Institute of Diplomacy and Human Rights here in the state of Nebraska. And we don't take positioning on proposed legislation, affirmative or negative. But we do provide trainings on this specific topic. I actually been trained this week on this topic. Well, I start my training this week. And consultants have the ability to set their own fees, so I can't speak for Washington, but I have a team of dedicated volunteers here in Nebraska, and we'd be willing to volunteer our time to consult on any training that might need done on this. My only concern is parts of the language being overtly ambiguous. Like I see 2 potential constitutional conflicts in the language. And there's like, I think 5 times that it refers the appointees of the board to be potentially or designated referral. So there are parts of it that are kind of open to interpretation. I had a question about the same thing the last speaker just mentioned, the last testifier. But I recognize the intent of the bill is well intended. So we want to be supportive of that. So we will follow the bill and be available to volunteer any of our efforts that are necessary. And I'll take any questions from the senators.
Okay, thank you for appearing. Other questions from the committee? Seeing none, thank you.
Appreciate it.
Are there any others that wish to testify in a neutral capacity? Seeing none, Senator Sanders, you're welcome to close the forward. I would like to say that we had from 4 proponents that had either written letters or sent us electronic communication. That's 4 proponents, 0 opponents, and 0 neutral. So with that, if you would like to close, please.
Maybe I'll just waive closing. But we do have fingertip information in front of you. It's the link to the website for the training. Bottom line, I attended a conference, an international conference this past summer, and people from around the world, legislatures were in the room, and what they've seen in human trafficking. And certainly other countries have seen it a lot worse. But we know we are the #1 providers of the customers in America, and Mexico is the #1 providers of the children. And we'd like to work together. We need to start somewhere. Our children are not for sale, and we need to be pretty loud and clear about that. But we also have to be aware of what we see, and we say something. And that's where it starts with each one of us.
Senator Blood.
Thank you, Chair Riepe. And Senator Sanders, you and I switched places, so I unfortunately had to miss your introduction, and I apologize for that. but I have read through what's on my pile here, and I reread through the bill, and I have a couple of questions. And in your closing, you talk specifically about children. I know we can't use props, but the things that I'm concerned about is the slavery, the human trade aspect of it. It seems that we, and we should be, are always concerned about the trafficking of children, especially for sexual purposes. But when I see the posters go up, I never see them about the adults that are being labor trafficked. And you've heard me tell the story that my family helped people who came over from Czechoslovakia in the 70s who were brought here by the Russian mafia and literally cleaning grocery stores in the Omaha metro area. Trafficking is nothing new, as we know. But if we're doing this, the question I have is, are we only doing what appears to be the marketing trend, which is for kids, or are we looking at the entire picture to put a stop to it when it comes to the posters and the training?
I think it certainly has opened up a whole bunch of conversations, right? We're looking at underage. That's very important. What we do as far as over the age of 18, prostitution and labor is how broad do we want to get? But I think we all need to be aware of what we see and what we report in this bill. So as we look at the entire aspect of human trafficking and illegal trafficking, not by someone's will, but taken in other ways, used, whether it's for labor, used for sex. We need to look at the broad aspect of this. I know the other day I saw a poster at the airport in the women's restroom that said, if you are human trafficked, and it was in several different language, call this number. And the first thing I thought of was, I don't think they would have a phone to call that number. So what else can we do? And so thank you, because that conversation, we have to look at all aspects and try to get a handle on all of it. But we need to start somewhere.
So my question still is, since I didn't hear the introduction, is the goal of the bill to address all trafficking, both labor and sex trafficking, both children and adults? And because I know that we do, as you probably said in your intro, in casinos and I can't remember, there's like 5 locations that we put them in, truck stops, and we have them in 2 languages in Nebraska, right?
Mm-hmm.
Are we just getting on the bandwagon of, I know that they just had that movie that came out that everybody watched, the Sound of Freedom movie. Are we just getting on the bandwagon, or are we actually doing this in a comprehensive fashion?
I don't think it's a bad thing to get on the bandwagon.
I
but if you
don't
look at
either.
the video,
I've been fighting it for decades.
Yeah, so the bill is about the training video, and the training video covers all aspects.
And so that's what our posters will also cover then?
Yes.
All right, thank you.
Any other questions?
Do you have more?
Pardon?
Do you have any more?
No, sir.
Okay, thank you. Senator Hansen, please.
Thank you, Chairman. Do you know, has this language, this bill been introduced in other states and passed in other states?
I do not know.
Okay, because I had also that concern about that last paragraph on page 7, like the language that the trial attorneys brought up. Those who comply in good faith with this section shall not be liable for an act. And do you have any intention of maybe kind of working on that?
Yes, yes. Ms. Scott and the Attorney General's office, we have been working together.
Cool.
Yes.
Thank you.
Open to that. Bottom line is, we don't want our children being sold.
Yeah, and I don't want like language to hold up the bills.
Yes, yes, we are working on that.
Thank you.
To address Senator Blunt's issue a little bit, is that you might say, like in many doctoral dissertations, they'll say there, here are other areas to study in the future.
Yes.
And so it looks like, in addition to what appears to be young women, there are probably other people that are being victimized, trafficked, whatever, that
Yes.
probably we and others need to look at it. The other question that I would have is, I have to assume that we're not the only state that's looked at this similar legislation.
I believe there are others. I don't know, but there are a few behind me that I can get you that information.
That was just a curiosity question. Most of these, being the first on anything is quite surprising to me for Are there other questions from the committee?
I just wanted to throw one other matter
Yes.
in this. If we aren't paying attention, what other countries are seeing is when they are done with trafficking these children, then the children's organs are harvested. So illegal organ harvesting has started with the children that are trafficked, and we never want to get to that point. We do have great hospitals right here in our location, and you know where your organs come from, but not other countries are so lucky.
Yes, welcome back. Senator
But
Blunt.
Senator Sanders, hasn't that been happening for decades in other countries? Because
I've just learned that.
Oh,
So
I was gonna say,
the
I have
fact
to
is
say it's not-
probably,
Yeah, it's been happening for decades. So
Mhm.
I don't think this is a new thing. I think this is a thing that narrative wells will get away with everything, get away with regardless of who their victims are. Doesn't make it right. Be it children, be it adults, be it poor people, be it prostitutes. Those that are most vulnerable are the ones that are the most vulnerable,
correct.
unfortunately.
Do you know if there's serious policing from the donor recipients, not the patient themselves, but the organizations? I mean, I would assume that they would want verifications to source.
We do that here, right? If you have an organ transplant, you know that line of organ, whether it came from a male, the age, city, sometimes the name, if it's agreeable. And we are leading in that in the world of making sure you know where your organs come from.
I do know there are Americans that go to other countries to have transplants.
We've heard of
So
those,
that's-
yes.
That might be the issue. Okay. Other questions from the committee? Thank you very much.
Thank you.
That concludes the hearing for LB 1408. We will now move to LB 1017. Senator Bosn, you are welcome. Thank you for being here. And if you would just, we'll get yourself passed out here. If you would just introduce yourself, and you know the routine, and the show is yours.
Thank you. So I'm having passed around the majority of what I'm going to talk about. Thank you, Chairman Riepe, and good afternoon to members of the Business and Labor Committee. For the record, my name is Carolyn Bosn, CarolynBosn. I represent Legislative District 25, which is Southeast Lincoln, Lancaster County, including Bennett. One of the things before I even get started with that, just first, because it was confusing even to myself when I agreed to take on this bill. So what we're talking about, multi-members versus multi-limbs. So you have an arm, it has multiple members. You can have a shoulder, an elbow, a wrist, but that's still one limb, right? So I have two arms, I have two legs, but I have multiple members on each arm and also on each leg. I have knees, I don't have elbows on my knees. I have knees, ankles, hips, those kinds of things. So you can have multiple members on one limb, but you have two limbs, two arms, two legs. Okay, so I introduced LB 1017 on behalf of the Nebraskans for Workers' Compensation, Equity, and Fairness. LB 1017 is designed to clarify the provisions of Nebraska Revised Statutes, Section 48121, relating to the circumstances under which the Workers' Compensation Court can award benefits based upon loss of earning capacity in cases in which a loss or loss of use of more than one hand, arm, foot, leg, or any combination thereof has resulted from the same accident or illness. Under the bill, loss or loss of use of multiple parts of the same arm, including the hand and fingers, or loss of use of multiple parts of the same leg, including the foot and toes, resulting from the same accident or illness would not entitle the employee to compensation for loss of earning capacity. In addition, LB 1017 would clarify that loss of use for purposes of a loss of earning capacity determination means permanent loss of function. The legislature adopted the workers' compensation reform legislation in 2007 pursuant to LB 588. And I did print some of that, so for those who have questions about that, I can try and answer questions on that as well. The primary component of that legislation revised the manner in which large hospitals were reimbursed in connection with workers' compensation claims, thereby reducing employer expenses. In addition, the legislation revised the manner in which benefits could be determined in cases in which an employee suffered injuries to more than one hand, arm, foot, or leg, or any combination thereof. This is the issue that's addressed by LB 1017. With the passage of LB 588 in 2007, a substantial change in policy was adopted, which benefited injured workers. The rationale for that change was that when more than one hand, arm, foot, or leg, or any combination thereof is injured and limited the employee, the impact of the injuries may be far greater than recognized by the schedule of benefits for the injuries to any individual member. In such instances, the employee should be entitled to receive more benefits than the schedule allows. Conversely, if only one hand, arm, foot, or leg is injured, there is justification to compensate the employee based upon loss of earning capacity rather than the statutory benefits for the schedule member. Since the passage of LB 588, a number of court decisions have been rendered which run counter to the original intent of LB 588 with respect to the loss of earning capacity issue, most recently culminating with the Nebraska Supreme Court decision in the case of Espinosa versus JobSource USA Incorporated. That's a 2022 case. In conclusion, LB 1017 is designed to address adverse impacts resulting from two separate decisions by the Nebraska Supreme Court. First, LB 1017, by defining loss or loss of use to mean permanent loss of physical function, will clarify that permanent restrictions to each hand, arm, foot, or leg, or any combination thereof must exist in order for the loss of earning capacity determination to apply. This portion of the bill would address the decision in Rogers versus Nebraska State Fair, in which the Nebraska Supreme Court held that it was not necessary for an injured employee to sustain functional loss in the form of permanent physical restrictions to more than one scheduled member in order to receive the benefits based on loss of earning capacity. Secondly, LB 1017 will address the Espinosa decision, which held that injuries to multiple parts of a single scheduled member, so that's two injuries on one limb, were eligible for benefits based upon a loss of earning capacity determination. LB 1017 will require injuries to two separate and distinct extremities or limbs for the loss of earning capacity determination to apply, thereby returning the state of the law to that originally intended by the legislature with the passage of LB 588 in 2007. Other witnesses to follow me will go into further detail regarding the manner in which LB 1017 addresses these court decisions. Thank you for your time and attention. I will be happy to try to answer any questions that I can.
Other questions from the committee? Would you say it's fair to say that the greatest contribution of LB 1017 is that it replaces language removing ambiguity?
Yes, it's a cleanup bill is the easiest way to say it.
Thank you very much. They'll stay around for closing, right?
I plan to, yeah.
Okay, thank you, thank you. I'd like to have proponents come forward, please. Mr. Jones, you know the drill here. You'd say your name and spell it for us.
Yeah, my name is Dallas Jones, DALLASJONES. I am an attorney with the Baylor, Edmund Wolf, and Tannehill Law Firm, and I am appearing on behalf of Nebraskans for Workers' Compensation, Fairness, and Equity. I am here as a proponent. I am supporting 1017. As the senator explained, there was a bargain that was reached through many, many negotiations in 2007. I'll explain a bit more of those in a moment. Because of those decisions that the senator referenced, that bargain was thrown significantly out of balance. It was not the intent of anyone involved with that bargain in reaching that bargain or those negotiations. And for that reason, 1017 is necessary to restore the original intent of LB 588. But let me take you back to 2007 and drill into that just a bit more. In 2007, the business community recognized that the Workers' Compensation Act required employers to pay hospitals amounts substantially greater than any other system that existed. They were obligated under the Workers' Compensation Act to pay more than any health insurer was obligated to pay or agreed to pay, more than Medicare, more than Medicaid. That was the impetus for LB 588, was to bring that back in line. In the process of bringing forward that bill, there were discussions with labor groups, principally the trial lawyers, about whether they would support it. And the answer was they would not support it unless some of the benefit that employers received from the reduction in payments to hospitals inured to the benefit of employees by virtue of some increased benefits. The business community agreed to that. Specifically, what they agreed to and what the trial lawyers proposed was that injuries to two or more extremities in one accident that resulted in permanent loss of function would qualify those employees subject to that to the potential for greater benefits. That brings us to just a brief discussion about the difference in how the Act compensates employees who injure their extremities, loosely speaking, versus employees who injure their back or their neck or their head or have psychiatric injuries. Basically, it works like this, and I say this to help you understand the significance of what that bargain was. Whenever one injures any of their extremities, fingers, hands, arms, toes, legs, knees, eyes, ears, hearing, they're included in that. There is a schedule that literally says the degree of percentage that you have lost of use of that particular body part, that scheduled member is called, then the greater the dollars that flow to the employee. On the other side, if you have the back injury, for example, the employee with the back injury is compensated in a different way. It's based upon that employee's loss of earning capacity. Loss of earning capacity generally refers to that employee's ability to find work for which they have training and experience, perform the work, and earn wages. And there's a percentage. In virtually every case, though, loss of earning capacity results in a greater recovery of benefits measured by dollars than the scheduled member does. So the significance of this compromise enabled some employees who had multiple injuries to different extremities to then tap into, if I can use that term loosely, the opportunity for greater benefits under that earning capacity construct. So we hashed it out, everybody agreed to it, and the bill passed. Since then, everything went quite well as expected until some of the cases that the senator referenced. Let me speak to how we know what the intent of that bill was. When that bill was before this committee and then on the floor, every single example used by proponents of that amendment to LB 588, the part that talks about the members, multiple members being injured, every single example given was in reference to injuries to different extremities. For example, Senator Nankus referred to, and these are quotes, both hands. She referred to bilateral shoulders, again, illustrating how this would be applied. Mr. Howard, one of the lawyers sitting behind me, testified at the committee about knee and rotator cuff, bilateral carpal tunnel syndrome. Senator Lathrop, both in this committee and on the floor, talked about 2 broken arms, 2 broken legs, bilateral carpal tunnel syndrome, a hand, and a hand. Since the bill passed, there were a total of 3 cases that made the case that it should be interpreted differently over roughly 13 years. I will continue if I may, or I will close if I should.
I'm going to ask you to continue on.
Okay, thank you, Senator. The rhetorical question is, if the intent of labor representatives, specifically trial lawyers, was that the intent of that compromise was that multiple injuries to one extremity should open that door to earning capacity loss. I asked, where have all of those cases been and why have they not been filed over the 13-year period before Espinoza was decided? There were two other than Espinoza. I would ask, when those individuals are here testifying today, press them to speak directly to that intent and ask them to point to any testimony, either in this committee hearing or on the floor for LB 588, that suggests or hints or implies that the intent was to enable an employee with multiple injuries to one extremity to be entitled to compensation based upon their loss of earning capacity. And ask them, if that was their intent, why is it that all of those cases that Senator Nankus referred to in her testimony in front of for LB 588, all of those cases, where are they and why were they never filed over those 13 years? That's because that was not the intent. That was not the intent of labor. That was not the intent of business. And that is the purpose of LB 1017, is to take this back to where the parties intended it was, so that in the event that there is legislation that somehow should be changed, we'll have that debate, a much broader debate that always occurs when there are claims for increases of benefits and what the impact is on both sides and what the best possible public policy is. That debate was never had because that was never the intent. We can have that if there's a bill that raises that. With that, I will stop and answer any questions if senators have any.
Thank you very much. Other questions from the committee? I have a question, and that would be, why now? Why this session as opposed to last session or the one before?
Sure.
What is the sense of do it now?
Yeah, timing. Timing meaning it was a little over a year ago when Espinoza was decided. Prior to Espinoza, we had the two outliers, two trial level decisions, literally, that talked about this different interpretation and none other. We did, I will tell you, in 2016 and in 2020, after those two decisions came out, we did come back before the committee with two different bills, basically asking to do exactly what 1017 is asking. I will note that in the committee testimony before those two bills in 2016 and 2020, there is not one of the opponents to our attempts to clarify, go back to LB 588, that made the case that in fact, what we were concerned was going to happen with Espinoza eventually was in fact the intent of what LB 588 was and the intent behind the bargain. Once again, this is simply a bill to go back to what the original intent was.
Okay, that's pretty good. Thank you. Other questions on the committee? Seeing none, thank you very much for being here. It's very informative. Additional proponents, please. Yes, sir. I know we've seen you before. But
Yes, you have, Chairman Riepe, members of the committee. My name is Robert J. Hallstrom, Hallstrom. I appear before you today as registered lobbyist for the Nebraskans for Workers' Compensation Equity and Fairness and the National Federation of Independent Business to testify in support of LB 1017. I've also signed in on behalf of the Nebraska Chamber of Commerce and Industry, the Greater Omaha Chamber of Commerce, the Lincoln Chamber of Commerce, the Nebraska Retail Federation, and the Nebraska Grocery Industry Association, also in support of the bill. Hopefully I haven't used up my time with the introduction.
That's why I give you 5 minutes.
Thank you. And in the interest of time, since you were so gracious to allow Mr. Jones to testify extra, I'll try to be brief in my remarks. I do want to thank Senator Bosn for becoming somewhat of an expert on the issue. So thank you for her time and effort in that regard. I think just a few things that I would note. When we look at this issue, Mr. Jones has indicated what the intent, what the benefit of the bargain was. And when we look at the Espinoza ruling, I think it's much different than what the analysis was that had been applied for many, many years by workers' compensation court judges. It's going to have an effect on how insurance companies manage workers' compensation risk. It's going to increase cost to employers, both in terms of insurance premiums and in terms of self-employers having direct increase in cost and potentially protracted litigation to determine whether or not there's a loss of earning capacity. We believe that the workers' compensation judge in the Espinoza case that was ultimately appealed to the Supreme Court and then the ruling handed down really got it right in terms of looking and highlighting what the real intent of LB 588 with regard to the loss of earning capacity provisions entail. The workers' compensation judge held, and I quote, "The problem with plaintiff's argument is that the statute requires a loss of use of parts of more than one member. A loss of use due to an injury to the wrist and the elbow in a single arm is not an injury to parts of more than one member. The arm is a single member, and any loss of use for an injury below the elbow would be included in the loss of use of the same arm." And the lower court, if you will, the workers' compensation court, thus held that the injury to the wrist and elbow in the same arm is an injury to a single member and would not entitle the employee to a loss of earning capacity determination. So in closing, I would suggest while those parties that were part of the original bargain are in fact entitled to the benefit of the original bargain, they should not experience a windfall, which is exactly what has occurred or resulted from the recent Espinoza decision. LB 1017 would take us back to that bargain and would encourage the committee to advance the bill for further consideration by the legislature. And I would just add, I think, you know, in retrospect, we probably inartfully drafted the legislation by referencing the word or the term member. If you read the Supreme Court opinion, they talk about member and scheduled member, and as a result, they were able to put together a determination that found differently than what the clear intent of the legislature was back in 2007. Be happy to address any questions that you might have.
Okay. Are there questions from the committee? Seeing none, thank you very much.
Thank you, Senator.
Additional proponents, please.
Good afternoon, Chairman Riepe, members of the committee. For the record, my name is Corby Gilbertson. It's spelled Korby Gilbertson, appearing today as a registered lobbyist on behalf of the American Property Casualty Insurance Association in support of LB 1017. I don't want to repeat what Mr. Jones and what Mr. Hallstrom said, but APCI very much agrees that this was not the way the bill was intended. There's certain bill numbers after you've been doing this for a while. It's kind of like a jersey that should be retired after the bill passes. 588 is one of those bills in my mind. We did spend months and months and months negotiating on this bill. I had to have someone actually do what Senator Bosn did for all of you, which explained to me what all these members were when I first started doing this. So it's very complicated, and it was a very clear and long drawn out process to make this agreement. And so I think 1017 does exactly what has been said. It takes us back to the initial intent of the legislation. And I would even say you can ask Steve Lathrop if that was it, because he would agree, because he was there with us. So with that, I'd take any questions.
Okay. Other questions from the committee? Seeing none.
Thank
Very
you.
much for being here. Additional proponents, please. Are there any that still want to speak in support of 1017? If not, is there any opposition? Welcome. You'd be kind enough to give us your name, spell it please, and then
You
who
bet.
you represent.
Todd Bennett, TODD-BENNETT. I'm here on behalf of the Nebraska Association of Trial Attorneys. I can't say I was here in 2007, but I was involved in the legislative committee. But in answer to several questions, I would like to draw just one point that Senator Bosn made on this Rogers versus State Fair case. Redefining the loss of use, this is well-settled law over 120 years. I can go back to 1964, taking fingers and toes out of it. That's been a case since 1964. So it's useless to even put that in there. Second of which, Rogers has a dichotomy every injured worker faces. When a doctor gives you a permanent impairment and then says, but I think you can go back to work full duty, even though you got a permanent injury. What's a worker to do? Now, the Rogers case deals with loss of use. The fact you have an impairment, the trial judge gets to consider what is the loss of function with that impairment. Because there's many doctors who, yeah, they'll give you an impairment, but they'll say you can work full time, even though you got a limit of range of motion, loss of sensation, and so forth. That has no business in this bill. It's never been part of any agreement whatsoever. And I actually urge you to take that out, because this law has been settled for 100 years on what a loss of use is and what it's not. Second of which, this bargain, I can't say I was there, but I've been involved in the committee for 28 years. What you're not going to find in that legislative history is one comment by anybody who was in for this bill saying one extremity, you can't get it for one extremity. That's not in there. And ironically, where are these cases? That if it came about in 2007, what everybody has to weigh is the time and expense to go through a court hearing, an appeals hearing, and then get a decision through the Court of Appeals or Supreme Court. Because a lot of people just don't appeal. I kind of want to give you a personal photo, because this is one of your constituents. There's no toes, there's a half a foot. There's also a reconstructed knee. There's also a fractured femur and a fractured neck below the ball and socket. That's 4 distinct injuries that under this bill, this lady who can't work isn't going to be compensated. She'll be compensated for these partial percentages, but in terms of disability, she's cut off, no pun intended. But what this boils down to is, I wrote several of these things down on this bargain. I've been meeting with the same group for probably over 10 to 12 years. Not one time has this ever come up in that meeting in 12 years. I was president of the bar or the Trial Lawyers Association last year, met with them. This wasn't brought up. Judge Koh's decision in 2011 and 12, this very issue, it never came up. Rogers, when it came up, was never discussed. 2017 and 18, when I brought a case in the Supreme Court, they actually defended the fact that an amputation below the knee, there's no compensation for the residual limb that remains. That was in the case in 2021 by the Supreme Court. Then we get to Espinoza, and this Espinoza decision, frankly, whether they like it or not, it's sour grapes. This has just come out and bail us out, because they made a decision to appeal it and they don't like the ruling. But what that decision stands for, I want to kind of put this in the backdrop. NCCI, who manages all the premium rates, compensation rates, all the data in the country. Who's the most profitable property and casualty commercial insurance? Work comp. 5 years running, they make the most money. 8 years in a row, they've made a significant $42 billion in profit. That's in the backdrop of this, because the agreement we made, whether they like it or not, there was no agreement saying this was limited to one extremity. Now, I can't speak on what Senator Lathrop and Senator Conrad may or may not have done, but in that legislative hearing, there's not one mention that it's limited to 2 extremities. There were examples, yes, of 2 extremities. But when we're talking about a wrist, just like this case,
Yeah,
5
we're not
missing toes.
supposed to use props, but.
Sorry. Well, 5 missing toes, a half a foot, a knee construction, ACL, MCL, a femur fracture with atrophy so bad that it fractured the neck of the femur. 4 distinct injuries, and this bill will cut off that disability. The bargain, there's no pain and suffering. This person isn't going to be compensated for disability under this bill. But what it boils down to is when they gave up the right for these artificial distinctions, that's what they are. They're artificial distinctions in these statutes. Industry bears the cost itself, not the injured worker alone. That's the bargain. LB 1188, if this bill passes, they're going to come in with more. Not only are we going to have increase in litigation, but we're going to have DHHS, Medicaid, local government for food stamps and so forth, because I guarantee you it's coming, it's already here. But I'll be more than happy to talk to any of them and any of you on this, because it's never come up as far as an agreement, especially in the last 16 years. And I'd be happy to answer any other question.
Thank you.
You bet.
Other questions from the committee? I have a question in
You
the
bet.
sense that, obviously you have a very strong knowledge and very strong opinion. Have you had the opportunity or taken the opportunity to talk with the bill sponsors and Senator Bosn about these?
Well, since I was president, took a step back after I'd been involved for 28 years. I wasn't involved in the agreement this year, but my understanding, the current president had a chance to meet with them, but this didn't come up, as far as my understanding.
Okay, well.
And I'd be happy to just talk about it.
Oh, we have it in the records. We'll go from there. Are there other questions? Hearing none. Thank you. Thank you for being here. Other opponents? Thank you for being here.
Thank you for having me. My name is Steve Howard, Stevehoward. And I'm the lawyer that was here in 2007 and sat at this desk at this testifying.
Who are you with?
I'm just Steve Howard of Steve Howard Law.
Oh,
But back then I was counsel for the state AFL-CIO, and I've been a NATA board member, but I'm here representing myself and Paulina Espinoza and several other Nebraskans that bring their cases in the Workers' Compensation Court. When Mr. Bennett talked about an artificial distinction, the way my friends on the other side would like to have the law read is that if you injure a right shoulder and a left hand, then somehow you get in the door to talk about this 30%. But if you injure a right shoulder and a right hand, no, that you don't. You can't talk about, you can't bring your case, if you have the proof, if you have the evidence, within this 30% threshold. And what is 30%? If a Nebraskan earns $60,000 a year and suffers a 30% loss of earnings, now their earning power is at 42,000. Every person in this room can just imagine the effect of a 30% reduction in your earning ability. But my friends on the other side who want to claim that the bargain was different, the history was different back 16, 17 years ago, say, well, we have to go right or left, or we have to go arm to leg. Let's talk about this 30%. What does it really represent? 30% loss of earnings. That's what Mr. Jones talked about for a body as a whole, where you have this pie or this pool of earning capacity, and then it's made smaller, and that's the measurement for a head or neck or back injury. For an extremity, for a member injury, rather, it's strictly according to the percentage from the doctor, from the AMA guidelines to permanent impairment. So if a worker who uses her thumb every day at work loses the use of that thumb and can't do her job, too bad. You get whatever percentage of that 60 weeks for the thumb there is. Below the elbow, it's 175 weeks. Above the elbow, 225. It's always a percentage. And no one would ever say, I want to lose my hand and get 175 weeks of benefits. But this 30% is payable over 300 weeks, not lifetime, even though it's a lifetime loss for the worker. And it may not even be 300 weeks because you have to subtract out the temporary benefits. So now you're under 300 weeks. Now, do you get the full amount of a 30% loss? Well, no, it's at 2/3. And the way the defense lawyers fight on this, you're probably going to have to share that with the lawyer. Otherwise, you're going to get nothing. These are intelligent folks that were there in 2007, and they're educated and they're well-trained. And you've heard today about all of the input and all the negotiations and all the buildup to the passage of the bill. Surely someone would have come before the committee and said, well, now, understand, we all agree that doesn't count. If it's on the same arm or if it's the same leg, we're excluding that. It would have taken a sentence or two, the proposed amendment that you see in 1017 to accomplish that. The examples that were given are examples of sufficiency, not of necessity. They're examples of inclusion, not exclusion. Lawyers are wont to say including but not limited to. Like I said, surely if this were such an important point of that grand renegotiation of the big bargain in LB 588, someone would have sat here and said it, or there would have been some language in the bill. Why have there only been 3 cases? Because examples like this are somewhat outliers. To prove a 30% loss of earnings is a remarkable loss. Mr. Bennett talked about the realities of workers' comp. There's $0 for pain and suffering, 0 for the spouse, 0 for scarring and disfigurement. There's no cost of living increase. And when you replace private insurance dollars and make it easier for the party to go into court and come out with less dollars than really accounts for their loss, what you do is you shift the burden to public tax dollars, because more folks have to go on Medicaid and Medicare and food stamps and social programs. So I'd encourage you not to pass any legislation that makes that shift. If labor and management want to come back together and talk about this, the stakeholders are out there. But this notion that, oh, everybody knew, and then the Supreme Court, through the Espinoza case, through my appeal, somehow pulled the rug out from under it, I respectfully suggest that somewhere in your record in legislative history, there would be some reference to that. So I respect my friends on the other side. Thank you for listening to my comments.
Thank you. Let's see if we have any, are there any questions from the committee? I'm sure that you got the attention of all the senators when you talked about a 30% loss in earnings on our $12,000 a year salaries. So, but thank you for being here. Are there any opponents, additional opponents? If you would, sir, if you'd state your name, spell it, and then tell us who you represent.
Yeah, my name is Nick Grangenet, spelled Nickgrandgenett. I'm a staff attorney with Nebraska Appleseed, testifying in opposition to LB 1017. So although we're testifying in opposition to this bill, we do appreciate the opportunity it creates to talk about workers' compensation because it's an important topic. Unlike injuries caused by car accidents or consumer products, workers can't sue their employers for the injuries they suffer at work. Instead, it's workers' compensation that provides them with a limited amount of wage loss support and medical benefits while they recover from that injury. And that's the cost of the workers' compensation insurance program, which is ultimately responsible for carrying the cost of that claim. So determining how a person's lost wages are replaced is a complex, difficult task. I think as we've heard today, it requires putting injuries into several different categories, even though the reality is an injury might not fit neatly within any of those different categories. The value in what the recent court cases have done is they've created a degree of flexibility that allows for a more fair, just, equitable workers' compensation system, particularly as it pertains to the benefits schedule. I think a common justification for bills like this that we've heard today is trying to reduce costs for the employer, particularly when it comes to insurance premiums. I want to take just a moment to talk about premiums. Through the research that we've done, we've seen that insurance premiums for workers' compensation for employers have been decreasing dramatically over the last 30 years. So if you look at 1994, which is the highest recorded level, the average employer was paying about $3.31 per $100 of payroll. As of 2022, the average Nebraska employer was paying only about $1.25 per $100 of payroll. And then as other testifiers have noted, it's worth highlighting how Nebraska's workers' compensation law is lagging behind other states in several key areas. So we don't have a cost of living adjustment like other states do, which means that the value of a person's benefits slowly erodes because of inflation over time. So if you look at a worker who was injured in the early 2000s, for example, the value of their benefits is only about half of what it would have been in 2000 as it is today. We also have the longest wait times in the nation. Every other state allows people to access workers' comp benefits more quickly than does Nebraska. So it's really for all of these reasons. The fact that a fair workers' comp system needs flexibility to ensure that people have access to the benefits that they need. The fact that the cost of workers' comp has been decreasing dramatically for employers over time, and the fact that we're lagging behind other states in several key areas that we would oppose LB 1017 at this time, and urge the committee to look for other opportunities to kind of modernize and update our state's workers' comp system. Thank you, and I'm happy to answer any questions.
Thank you very much. Are there questions from the committee? Seeing none, thank you very much for being here. Are there additional opponents to 1017? Seeing none, are there Any individuals wishing to testify in a neutral capacity? Seeing none, Senator Bosn, you are welcome to close. And while you're doing that, I will say we had in correspondence from letters and electronic communication, we had 0 proponents, 1 opponent, and 0 neutral.
Thank
So
you.
The show is yours.
Thank you. So I'll be brief. We kind of talked a little bit about what the intention here was, where it stemmed from. This came from a legislative bill in 2007, LB 588. I didn't hear any of the opponents who clearly are upset about this prospect articulate that this was the bargain. It seems as though the bargain was clear in the testimony, both in the committee and on the floor, that the intent of LB 588 was to allow for multi-limb injuries to be treated differently than injuries to the same arm or leg. I feel like we're playing a game of head, shoulders, knees, and toes, but it's more like hands, shoulders, knees, and toes. But the original intent was clear in the conversation that was had both in the committee and on the floor, and all of the individuals who testified at that time were on the same page. Certainly the courts are allowed to interpret that, and then we react. So this is the reaction to that court interpretation that expanded the original intent. I brought this as a cleanup bill. I think it clarifies the language. Certainly, if those who are opposed to this bill wish to open it up to be treated differently, they can bring that legislation. But given that that wasn't the intent of LB 588, that's not what my position is, that that's not what the intention was, and we should be clear in treating it for its purposes of original intent. And with that, I will answer any questions.
Okay, let's see if we have any questions. Any questions from the committee? Saying none, thank you again. Thanks for your presentation. With that, that concludes our hearing on LB 1017. And we will move forward with Senator Hansen on LB 1393. Senator Hansen, the show is yours.
I'm assuming my bill is going to be a little less lawyerly than the last one was. Understood half the stuff they were talking about. Good afternoon, Chairman Riepe and members of the Business and Labor Committee. My name is Ben Hansen, that's BenHansen, and I represent Legislative District 16. The college athletics landscape changes every day, and it is with this in mind that I bring LB 1393. This bill provides institutions in Nebraska with an increased flexibility to adapt to the changes happening on a national level in the arena of NIL student athletes. I want to take a more proactive approach in enhancing the student athlete experience and put every institution in the state in a better position to retain and recruit athletes. Currently, institutions work with student athletes at an arm's length capacity, and that is insufficient for the institutions themselves, as well as the companies, fans, and the student athletes. My purpose for LB 1393 would allow institutions to better utilize department resources and assist student athletes with NIL activities. Universities support students throughout their entire college experience, and it only makes sense to be able to offer direction if they ask for it when it comes to NIL. Next, LB 1393 would allow institutions to better activate existing relationships with corporate sponsors and partners. They would have the flexibility to take an active role throughout the process of NIL opportunities from induction, creation, and fulfillment. Another aspect to NIL that has been a priority for the state of Nebraska is the protection of student athletes' information. We have taken steps to guarantee privacy throughout, requiring students or the authorized companies to disclose NIL activities to a third-party software platform that we can review. However, LB 1393 expands our intentionality in protecting the private nature of the business relationship between student athletes and third-party entities by prohibiting terms of a student athlete's NIL agreement from being made public. And finally, LB 1393 prepares for potential changes that could come through the guidelines of NIL on a national level. To remain competitive, institutions in Nebraska will be able to compensate a student athlete for the use of the student athlete's name, image, or likeness, should that be allowed by College Athletic Association policy change, court order, or settlement agreement. LB 1393 is clear though, if a day comes when institutions can compensate student athletes for the use of their name, image, or likeness, the fact alone does not make them employees of the institution. I've worked with Governor Pillen to create language that gives us the tools to recruit talent in Nebraska and keeps us taking initiative for NIL opportunities in our state. If you have any questions, I would be happy to do my best in answering them. Otherwise, there will be testimony following from those who have more insight on the subject. I appreciate your time and consideration this afternoon and ask for your support for LB 1393. And I do have to give a shout out to my colleague, Senator Hunt, for introducing LB 962 in the 2020 session, which started the Nebraska Fair Pay and Play Act.
Very good. Other questions from Senator Blood?
Thank you, Chair Riepe. Senator Hansen, what is that third-party software that they utilize?
I don't know off the top of my head. I thought I had my notes, but that might be a better question for somebody behind me.
Thank you.
Okay. My question is this. I'm sorry, Senator McKinney, please.
Thank you. Thank you, Senator Hansen. Just last week, the National Labor Relations Board ruled that Dartmouth athletes can unionize, which means they're gonna push Dartmouth to start paying their athletes. And I think the Supreme Court has kind of signaled as well that they're gonna rule that it's basically schools have to pay athletes eventually. How do you foresee that with this bill and anticipate that happening?
Yeah, there is a section of this bill, and I didn't bring that up in the opening, that would specify that student athletes would not be employees of the university. And so now how the Supreme Court rules on it might have some bearing on what's going to happen with this bill and in the court. I know some of this has to do with, the whole NIL arena is ever changing, and the NCAA hasn't really ever, I think, made any concrete rules on NIL, so they're kind of leaving it up to the states right now. I think right now we're just trying to change with the times and protect the student and kind of the university as well.
Okay. All right. Thank you.
Go ahead if you have another question.
I'm finished.
Okay,
Thank you.
Thank you, Senator. My question would be, is this based on the California model? I think they were the first or one of the first.
I don't know about this in particular.
Okay.
Yeah.
That's fair enough. Okay. Are there other questions from the, no? Okay. Thank you very much. Thank you for being here. So we'll ask for proponents. Welcome, Governor Pillen. It's always an honor.
Thank you. Thank you, Chairman Riepe and members of Business and Labor Committee. Thanks for the chance to visit and testifying in behalf of 1393. My name is Jim Pillen, J-I-M, P as in Paul, I-L-L-E-N, and have an incredible privilege to serve as the 41st governor of the great state of Nebraska. I'd certainly like to thank Senator Hansen for partnering with me on LB 1393, which I believe will bring a competitive advantage to Nebraska's universities and their NIL structures. I'm here to talk to you today about one of my favorite topics, college athletics. LB 1393 will give Nebraska colleges and universities the tools necessary to compete, to attract top talent, while also, most importantly, protecting our student athletes. The NIL space, the last 3 years, I think is the best term to describe it would be called the Wild West. No rules anywhere. Universities have tried to responsibly navigate this space with virtually no guidance. I think the best word to use when we refer to the NCAA is they have been missing in action on this topic and pretty well wiped their hands of it. And that's why it's really important that our own states come forward with NIL law. And that's why I've worked with Director Alberts and the team at the Nebraska Athletic Department to find a way to make our laws the most competitive. And the NIL space is certainly changing the landscape of college athletics. We either have the choice to compete or stay on the sidelines, and my preference would be that we would compete. Athletics at the University of Nebraska women's sports leading the way this year in terms of popularity, and Nebraska athletics is one thing that is incredible how it brings Nebraskans together. So this new legislation will not only protect our institutions, but most importantly, our student athletes. This legislation clearly states what is allowed by the programs and their athletes. This legislation will allow the institutions to work more closely with third-party entities to make sure the student athletes are not being misled and being given appropriate assistance with their NIL deals. I think that's really important, that can't overstate it, to make sure that there can be engagement so that the student athletes are protected and not duped in this process. Ensuring that no young athlete will be caught in the crosshairs of a technicality whenever the NCAA would decide to be involved. I believe this new legislation will put Nebraska out front as a competitor, making us an attractive state for all the young talent across the country. I believe we need to be sure that we are leaders in this issue. Things are moving slowly within the NCAA. The NCAA is, as I said earlier, quite frankly, just missing in action on this issue. The state laws across the country are the guiding lines for the institutions, and we must be sure to stay ahead of this and allow to recruit the top talent to our state. I think most people in the athletic space would all agree that great athletes help make coaches great. It helps. And I think that the other piece that we'd be remiss if we ever talked about, I would tell you, I'm personally amazed at how many student athletes come from all over the country and they fall in love with Nebraska and they live here the rest of their lives. And so there's a whole lot of things that are great about being able to compete and bring great student athletes to the state of Nebraska. And it's always fun if we can fill the stands and bring Nebraskans together. So I appreciate the time to visit. I'm happy to take any questions. There's an NIL expert with the detail, but I'd be happy to take broad range questions.
Okay, let's see if we do have any questions. Any questions from the committee? Seeing none, I was going to respond to that. I did read somewhere there was a young athlete by Carson's, his last name was in maybe Tennessee. He was seen on campus driving a $270,000 Lamborghini. So he's been a sophomore on.
You know, one of the things that I think is really where the University of Nebraska has been light years ahead of other institutions is, number one, giving student athletes guidance, whether it's academic. Coach Osborne was the first to have an academic counselor, and now the student wellness program where kids will have guidance and help. I'm sure that some might spend their money foolishly, but hopefully there'll be great opportunities to help kids save their money and not be driving a Lamborghini, because it probably won't last very long.
Well, mine was an observation, not a criticism of the young guy, so good for him.
Yeah.
Senator Blunt.
Thank you, Chair Riepe. I was writing down some of what you said, and I'm hoping maybe you can clarify this for me. So you said that this language makes us the most competitive. Where in the bill is that language that you're talking about that makes us the most competitive?
Yeah, so I think what I mean by that would simply be that by the state having a position, that allows us to be able to follow the rules that we have in the state, that we can compete with anybody, because if we don't have a state law, okay, if we don't have a state law, there's a risk depending upon if a third, right now, the university's ability to interact and help a student through the NI deal is really, really negligible. The goal would be to be able to have this law so that there can be interaction, so that the student athlete can be protected in making those deals, that they don't get taken advantage of.
So not the language per se, but the fact that we have a bill.
That we have a bill
Okay.
that would, protect the student athlete.
And then you also said that it protects, how does it protect?
How's it
How does it
protect the
protect our
student
students?
athlete? Yeah, so where today, a coach or university personnel is not able to be involved between the collective and making a deal with the NIL student. This would allow personnel within the university to be a part of that, to make sure that there's capacity that's done it a time or two and can help the student athlete make sure that their interest and that they are rewarded appropriately.
So if I hear you correctly, the protection that you talked about is by allowing staff to act as a
Yes.
mediator?
Be a part of the process. Today, they're not able to be.
All right, thank you.
Okay, thank you very much, sir, for being
Thank you
here.
very much. Thanks for all you do.
We appreciate it. Are there additional proponents who'd like to speak? If you would, kind sir, if you'd give us your name, spell it, and then share with us who you represent. And then it shows yours.
Thank you. Good afternoon, Mr. Chair, members of the Business and Labor Committee. My name is Jonathan Bateman, Jonathan Bateman. I work for the University of Nebraska Lincoln Athletics Department. I work in the NIL and governance space. Thank you for allowing me to testify today, and I'm happy to answer any questions you have about name, image, and likeness.
Okay, other questions from Senator Wood and then Senator McKinney?
Thank you, Senator Riepe. And thank you for coming in today. So you heard my conversation with the governor. So if staff is acting as a mediator, is then there the ability for staff to be paid for those services? Was that part of the intent?
Not as an agent per se in negotiating deals, but as a resource for educating the student athletes about best practices in the space. Right now, in NIL, and no one really could see when this bill was introduced and prior to July 1st of 2021 of how it was going to really expand to what it is now, right? So we had a great bones of a bill, and it is great, but now we just need to flesh out some of the specifics. And right now we have to be at arm's length when we're working with our student athletes, when they're working with companies
Right,
about.
that's my concern.
Yeah, and it makes it really difficult for the student athlete. They'll come to me and say, Jonathan, what do you think about this? And there's only so far I can go for education, whether I go over the line and then I'm in the NCAA's crosshairs for some of the guidelines, right? And if you have protections in your state law, then that does give you some ability to really provide our student athletes a good all-around experience, and that's kind of the intent.
But if indeed these are for protections, why would we take money for it?
We wouldn't take any part of their NIL deals. It would be staff members helping student athletes like we do in any other space of their life.
So there's no other compensation coming from not coming from the university, not coming from.
Aside from employing staff members at the university.
So additional staff members.
Right now, it is myself in the NIL space, and then any of our staff members who work in life skills, academics, et cetera, to help benefit our student athletes.
Okay, so I'm just a little confused. Okay, so staff will stay exactly the same. There won't be any additional costs because you won't be hiring more people to help with this, or that's what I'm trying to clarify.
Yeah, that's a great question. The way NIL is today, and I haven't been on my phone for the last couple hours, so it could have all blown up by the time we're done here. I'll never say never about hiring new staff or anything. I think we do a pretty good job at the department and try to rely on the folks we have to retrofit what we need in a specific instance. But what I can tell you is it's not going to be a situation where the institution is an agent and taking 20% of a deal or 30% of a deal of a student athlete's money that they have with a company.
And so how are they not protected if we don't have this legislation, besides the fact that they can come to staff and.
Yeah, in a couple different ways. I think one, allowing staff to help explain to them the differences and work with certain companies on their behalf to understand, good companies versus bad. But I also think a greater protection for our student athlete goes within the public disclosure piece within the bill that would protect their private deals with third parties to be not disclosed by a FOIA request by the university.
But aren't they adults capable of making these decisions?
Yes, they are. Yes, they are. And I'm amazed by our student athletes every day, how mature they are in the things they can do. But at the end of the day, we're also an institution of higher learning, and these individuals are 18 to 24 years old, and you don't know what every background of every student athlete is. So we feel it's our job to be a good resource for our student athletes when they come, and to help them out wherever it may be.
And what was my last question, I promise?
No,
What was
that's
the
okay.
Third party, because I feel like the way the bill is written in the introduction that I'm not hearing all of these things. So they refer to a third-party software in the
Sure.
introduction. Can you tell me a little bit more about that third-party
Yeah,
software?
we have a great relationship with a Lincoln company, Open Doors, which is run by a couple of former football student athletes at Nebraska, and they have a NIL platform that we use to disclose.
They have a what platform?
It's a software platform online that student athletes have an app on their phone to disclose NIL.
And so, okay. So third-party software always concerns me especially when we're supposed to be trying to protect students. Because as we've seen over and over again, and the university's been involved with some of that, is that things are so easily hacked and information can be resold. And what's to prevent this third-party software company from selling this information?
I'll have to get back to you on that, but what my understanding of our agreement with them is that would be a breach of the contract that we have with them for selling exact personal identification. But I can get that information.
So
for the
how do they
committee.
make their money for the software?
We are charged a fee for the software.
And what is that fee?
I don't know off the top of my head. I can get that information to
I
the
would
committee
like
as well.
that. Thank
Yeah,
you.
sure.
All right, that's all my questions.
Oh, that's okay.
Thanks.
Yeah, you're welcome.
Senator King.
Thank you. Thank you. Being a former athlete myself and dealing with NCAA compliance, one thing I always thought about at the beginning of the season, I just felt like we used to sign away our rights every year and nobody fully explained that to us. And I guess my concern is, do you not see a potential conflict of interest by not having somebody in the middle between the athlete and the school explaining what those rights are? Because that's what I always thought was weird. Our coaches would bring us in, maybe somebody from compliance, like at UNO, when I was at UNO, would come in and say, hey, you guys need to sign all these papers or whatever. And we would just be like, all right, I just want to get out of here. But nobody really explained we were really signing away our rights. So I guess who's in between making sure that athletes fully understand when you sign these papers, you're signing away your rights?
Yeah, that's a great question. The bill does allow for student athletes to have agents should they want them, to serve their best interests. What I have seen over the last 3 years as it relates to agents is that mostly high profile student athletes, the ones that are doing the majority of deals, have agents and use that right that they're afforded to. But some student athletes don't have them or don't want them, and they still need help with education as well, to understand some of the rights that they have and do not have.
All right. And one other concern of mine is in section 2, part 7B, it says a post-secondary institution shall not compensate a student athlete for their name, image, and likeness. And why that is a concern to me, and it's always been a concern, even when I was an athlete, not that I was good enough to really make money, but just thinking about some friends I had playing on the D1 level, you have this college playoff, you have bowl games, you have jersey sales, and the athletes get no money, but the schools and the conferences make a bunch of money, and the athletes get nothing. But you know who number 15 is. But number 15 gets nothing off those jersey sales. It goes to the university. And they're pretty much under this bill, they would get nothing. But we all know who number 15 is. And I'm just using the hypothetical number 15. But we all know who that is. And everybody's buying the jersey because number 15 scored a touchdown and won a playoff game and brought a national championship to the school. And even like for the Huskers, like we know who Eric Crouch was. Everybody wanted number 7. And I don't know. Maybe, hopefully one day the Supreme Court actually rules on this. But that's just a concern of mine of they're signing their rights away. In this bill, it says the school shall not compensate. But if the Huskers make the playoff, the athletes win. The school makes a bunch of money. But the athletes get no percentage of those earnings at all. And I just think that's a problem.
I appreciate and understand your point on there, and I have a couple thoughts. The first one now is with the NIL bill as it is currently. One great thing about it is student athletes would be able to be compensated by our group licensing partner for the sales of their jerseys. You know, that has their name on it and their number, which is, you know, a step in the right direction. I agree. The reason from my perspective that there is language in the bill that states that student athletes could not be compensated unless one of 3 things happens. And one of those 3 things are a potential settlement of the legal cases. I couldn't name all of the legal cases right now or in the college athletics landscape. You rightfully so discussed the NLRB case earlier related to Dartmouth. There's a House case out in California related to the Fair Labor Standards Act. There's a USC case with the NLRB out west as well. So, you know, should something happen in that space where any of those cases are settled and we can compensate our student athletes, or President Baker with the NCAA has also made a proposal about compensating student athletes. We would want the flexibility for our institutions in Nebraska to be able to do that. So that's why we included that. Settlement, association change, or a judgment.
I get that, and I understand it. I think California stepped out there, I believe, and set the pace on all this because they were like, we're going to be the leader. And I think about, why can't we be the leader and say, you come to Nebraska, we're going to pay you. Bring the national championships here, because that's what they're coming for, is to bring back the tradition of winning from the 90s. I don't know. I just think, we could be leaders in that and saying, we're not going to wait on the Supreme Court. We're not going to wait on the NCAA, who was definitely slow to move. We're going to step up and say, we'll pay you if you come to University of Nebraska or Creighton or anywhere else. But that's just my wish. But I understand why it's like that. But I just think, like, if we really want to get the best athletes, we should just step up and just pay them. But I appreciate your testimony, though.
I appreciate your perspective.
Thank you, Senator Blow.
Thank you, Chair Riepe. I'm sorry, I lied. I have one more.
Oh, that's okay.
So, you gave me too much time to start researching. So I was looking up the open doors. Would you say this is a correct description? Athletes browse the open opportunities and apply to pre-built offers. The listing brand or fan reviews the athlete applicants. The brand or fan sends an offer to the athletes they would like to work with. After a chance to negotiate, the deal is accepted and terms are completed through open doors deals.
Correct.
That's accurate?
Correct.
So standard fee is 30% per transaction for the student. It's one of 5 different options that students have to use. Why are we picking one particular option for them to use?
Pardon, Can you, what are the options? I'm sorry, I didn't understand.
So there are other software, third-party softwares that are available for the students.
Mhm.
In addition to Open Doors, I was able real quickly to find 4 others. I know there's 100,000 athletes on the Open Doors right now that are competing for sponsorships. Why would you decide to go with Blake Lawrence and his organization?
Yeah, it's a great question. I can look back to when we signed the contract.
Is it our job to pick out software for these students?
I think it's our job as an institution to provide them with opportunities to connect with fans rather than in giving them that software opportunity to do so.
Wouldn't they have that without you?
Correct, but I think the barrier to entry would be a little too high, and the other area of why we present the opportunity for the student athletes is to avoid them having to give out personal information to companies and fans or allow them to do it.
But they're already doing that with any third-party software.
Within the Open Doors app, they message each other within the app, so they're not giving them, direct messages on social media or their personal cell phone or email.
So you'll be paying that 30% transaction fee then?
The companies that work with the student athlete pay the 30% transaction fee.
Thank you.
You're welcome.
Okay, are there other questions? Seeing none, thank you very much for being here.
Thank you.
We would ask for additional proponents. Welcome.
Good afternoon.
If you'd be kind enough to state your name, spell it please, and then who you represent.
Yeah, my name is Nick Henrich, Nickhenrich, and I also work for the University of Nebraska, and I'm a former student athlete as well.
Thank you.
I'm a Nebraska native. I grew up in Omaha and attended Omaha Burke High School. In my senior year, I was a part of a Class A state championship team and was awarded the 2018 Gatorade Nebraska Player of the Year. I graduated high school early and enrolled in the University of Nebraska in January of 2019 to join the football program. I earned my bachelor's degree in psychology May of 2022 and finished my football career in December of 2023. During 5 seasons, I played 35 games, earned a black shirt, and was a 4-time academic All Big Ten selection. I'm in a very unique position to provide testimony because I was a student athlete before and after legislative changes provided student athletes with the opportunity to earn compensation for the use of their name, image, and likeness. And for me personally, NIL was a big financial help to my family as well as myself. Football is a extremely unforgiving game, and injuries ended up derailing my career and causing me to retire. So I didn't get a chance at the NFL, but NIL really allowed me to set myself up better for the future and provide me and my family more opportunities. The ability to work more proactively with my institution, tap into resources and relationship, all while better protecting the private nature of this business relationship is what I consider enhancements to the student athlete NIL experience. I appreciate the Business and Labor Committee for affording me the opportunity to speak to you all today, and I would encourage the committee to support the bill, and I'm also willing to answer any questions.
Thank you for being here. Other questions from the committee? Nice job. Thank you very much. Additional proponents, please. Others wishing to speak, or do you want to speak in favor? Are you a proponent?
Yes, but can I fill out the green sheet that's right?
Okay.
My name's Scott Thomas, SCOTTTHOMAS. I'm with Builds in Progress, Nebraska. And it's my understanding that the end of the bill is aimed at protecting intellectual property rights limited to a degree. And so I would testify in support of this bill. For that reason, Article 27, Section 2, and I don't always do this, but I'm gonna read right to y'all from the Universal Declaration of Human Rights. Article 27, Section 2 is everyone has the right to the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. So I support it for that reason. And yep, that's all I have. Senator Hansen is really good about always being really concise with the language and everything and the intention. So that was pretty good and easy to follow. Any questions for anybody?
Okay, just saying, let's see if there are any questions from the committee. I see none. Thank you very much for being here. Additional proponents? Seeing none, any opponents, if you will? Seeing none, is there anyone here speaking in a neutral capacity? Seeing none, Senator, you're welcome, Hansen, you're welcome to close. I will say while you're coming to the mic, we had in written or electronic correspondence, we had one proponent, no opponents, and none in the neutral capacity. Closing is yours.
Thank you, Chairman. I thought I'd just come up here and anybody had any questions for me? You stole my thunder. I looked it up online, the third-party platform took it from me, so I tried to look cool there and answer that for you, so sorry.
Senator Hunt.
Thank you, Chairman Riepe. Thanks for introducing this. I actually know a lot about this, and I could have answered a lot of the questions that were asked here. Can you explain how this limits the ability of student athletes, how this would limit the ability of student athletes to freely enter contracts with businesses and any entity that wants to sponsor them as a student athlete?
I think not with the bill, with the bill that I'm introducing here, yeah, I don't see how it limits per se, but more enhances, I think, the experience that maybe they go through.
How does it enhance the experience?
Yes, that's a good question. And so enhances.
Call it limit, whatever, you know what I'm talking about.
Enhances as in
Answer,
like,
you know,
yeah.
answer my question.
It kind of opens up that relationship, I think, between the university and lines of communication between the university, between a third party, and between the student, I think, a little bit more. Also protects their privacy rights and also protects the university and also the coaches as well, in case there happen to be, some issues, arising. I think it just clarifies certain language that you introduced before because of the ever-changing nature of the NCAA, their lack of response, I think, and the nature of NIL. And so in that way, I think it enhances it because I think it opens up that communication between all three parties.
Thank you.
Senator Hunt, do you have any follow-up questions?
No.
Okay, thank you. Thank you very much. Are there other questions from the committee? Seeing none, thank you very much. We appreciate it.
Thank you.
And, Governor, we appreciate you being here.
Motion to